Welcome, everyone. My name is Eric Esteves, and I'm the Executive Director of the Lenny Zakim Fund. Thank you for joining us today for this seminar on housing defense, eviction defense and housing justice by our friends at Greater Boston Legal Services. As you know, the state's moratorium expires tomorrow, October 17th, and there's a lot of activism and advocacy ongoing, yet GBLS and the Zakim Fund are very much concerned about the looming wave of evictions that may hit our state and impact affected communities around the Commonwealth. GBLS has graciously offered to provide some updates and training around eviction defense and assistance tools, as well as answer questions around ways in which providers can provide just-in-time supports and services to those impacted by the moratorium expiration. So with that being said, I will introduce our guest speakers today. First off, we have Danielle Johnston, who is a staff attorney in the housing unit of GBLS, where she works with tenants who are in danger of losing their housing. Prior to her work in the housing unit at GBLS, Danielle worked in the Elder Health and Disability Unit, where she worked primarily with elders, ensuring that they were not displaced from their homes. Next up, we have Lauren Honigman, who is an attorney with HomeStart, situated at GBLS, who focuses on eviction defense for tenants residing in subsidized housing. She worked as a social worker with CPCS, Committee for Public Counsel Services, prior to coming to GBLS. It's a lot of acronyms. Lauren Forbes works in eviction defense at GBLS and has a background in family law and juvenile defense, and spent time managing family shelters before coming to housing. And lastly, Dina Zakim, who's also a member of the Zakim Fund board, specializes in cases involving tenants with disabilities who are facing eviction and/or subsidy termination, and worked as a housing advocate for HomeStart prior to becoming an attorney. And with that being said, I will pass it on to Dina and Lauren, who will take over.
Yes, thank you, Eric. So I'm going to start sharing the screen for, let's see, for the PowerPoint. But before we jump into the PowerPoint that Lauren Forbes and I will be going through, we thank you all for coming. I think we're all very anxiously anticipating what's headed our way when the moratorium lifts tomorrow. And we expect that you all might be having to work with members of your organizations to assist with some of the eviction defense in terms of possibly using the online system of MAID that Danielle and Lauren will walk everyone through later. And we just expect it's going to be very hands-on and quite frankly, pretty frantic for a lot of tenants, and want to be able to share the information we have and share information about how to access our services and how we can work with tenants and clients and arm them most effectively for what's headed our way. So let me just start the slide, and Lauren F. is going to start us off here. And take it away, Lauren. Oh, Lauren, you're on.
Sorry, I'm on mute. Okay, sorry. Lifting of the eviction moratorium. The Lenny Zakim Fund and Greater Boston Legal Services present the Housing Justice and Eviction Defense Seminar, which much thanks to our Zoe Cronin. On October 17, 2020, Governor Baker has stated he will not renew the eviction moratorium, which is set to expire tomorrow, October 17th of 2020. Over $429 million in back rent is due. Up to 1/3 of Massachusetts tenants, have not been able to pay their full rent. Unemployment remains high, and for many, unemployment insurance has run out. Housing Court will be running 5 days a week, 8 to 4 p.m., hearing up to 3 trials per now. Prevents CD moratorium. Prevents the actual eviction on cases where the tenant owes rent due to illness or job loss until December 31st, 2020. However, courts that have indicated they may still process the eviction case. Tenants must file a declaration as soon as possible, best if before receiving a notice to quit. And we have a link below right here, Mass Access, that we can help you as well.
Yeah, and this is something that you might be hearing about from members you're working with, and it's best if they can go to this link on the slide and fill out a declaration, and it talks about how they need to have a moratorium continue for them based on the CDC moratorium, and we're advising people to get it in right away to try to stop evictions from moving forward. And please feel free to ask questions either during or at the end of the slideshow.
Thank you. CDC moratorium eligibility and criteria. Income. Expect to have income less than $99,000 in 2020 or have received a stimulus check or now have been required to report income to the IRS in 2019. Rent. Be unable to pay full rent due to an income loss or something to the matter of extraordinary medical bills. Assistance. Have you used best efforts to obtain governmental rental assistance? Homeless. Be likely to become homeless or forced to live in close quarters in another residence if evicted. And promise. Promise to make timely partial payments that are as close to full payments as the individual circumstances may permit. RAF funding. Apply at your local HCEC in Greater Boston. It is Metro Housing Boston or call 211. Governor Baker just announced he will add $100 million to his fund. Tenants and landlords may be able to obtain up to $10,000. RAF will prioritize those with court cases but don't need court cases.
All right, so I think this is where I'm jumping in. Thanks, Lauren. So the courts are reopening on Monday as the moratorium ends tomorrow on Saturday. We are expecting it's going to be very busy. First, what we understand from the courts is they're working through the cases that have already been filed and that may have been put on hold because of the moratorium. And then something new is that every case will have a first court date that's a status check and mediation. So rather than before how it could have been a trial right away, the first part will be mediation. So we're hoping to be able to help with advocacy there and make sure tenants aren't signing agreements that they might not be able to comply with, and just understanding what they are in fact promising to do. And I'll talk a little bit more about mediation shortly. The second date will be the trial potentially, and that is unless a tenant requests a jury trial, which can often significantly delay the case, but also practically gives the tenant the right to have a trial before their peers and share their side of the case before a jury rather than just a judge. We generally recommend that people do request a jury trial for those reasons, and it is their constitutional right. Then something that we are expecting is that many landlord attorneys and landlords are going to be approaching tenants outside of the court process in informal ways, which may seem quite different than when you're in court, but they will be having clients and tenants enter into binding agreements that can in fact result in their ultimate displacement. So we just want people to be kind of on the lookout for tenants being approached and making sure we're advising them to be careful about what they're signing and really understand it, and even potentially contact legal services to have someone check it out before they sign on to anything that could be dangerous. The answer, discovery, and jury demand are some of the most important pieces of the eviction case. Every tenant who gets a summons and complaint should fill out the answer and discovery and jury demand. When they get their court notice, which is the summons and complaint, it will have a date for when the answer is due. And that Lauren and Danielle are going to walk us through the MAID system, which is the online program to help tenants put in their answers and discoveries, and that's where they basically are able to share their side of the story. The landlord has said they intend to evict them for certain reasons, and then the tenant gets to answer and say why they actually should not be evicted. And then they get to ask questions about their case in the discovery and saying, if you're trying to evict me, you have to show some evidence as to why that should happen. So we're expecting thousands of people to need to fill these out on their own, people who might not have access to any advocates or services. And then we hope that they also will, contact organizations like where you all are and see if they can get some assistance there. The program that is the online system is one of our attorneys created it, and it is really very user friendly and is meant to be able to be accessed by anyone. But of course we understand some people will still have some difficulty with it. And if that is the case and there's no one else to assist, please tell people to call our office. And the number is right here, but it's 617-603-1807. If someone really can't complete it alone, because it is very important that they get this in so they don't waive any of their rights. And then if you want to go through it, it's on the website right there as well, gbls.org/made. So getting more into the mediation, a lot of what people often hear about housing court is more in terms of the defenses you can assert and the trials, but in reality, most cases end up in agreements, not trials. So something we want to make everyone aware of is how important it is to understand an agreement that you're signing. As I said before, the first court date after this moratorium is lifting is now going to be set for mediation. So there will be court programs set up to help with mediation, but a lot of it will be occurring informally, which is actually how it used to be as well when we were all in person. There would be like hallway chats with generally landlords represented by attorneys and tenants on their own, and you'd be doing a write-up of the agreement out there. We want to emphasize that attorney of the day is available and tenants just have to ask. That would be something that would allow them to have an attorney read over an agreement before they agree to sign it, to just make sure there's no really problematic provisions in it, to make sure the tenant is protected and not waiving too many rights that could put them in a scary place. Right now, and even before COVID, we would recommend against explicit move-out dates, because while you might think 3 months sounds like a time that you could find another place, it is very hard these days to find new apartments. So we are recommending trying to negotiate something other than a move-out, potentially some repayment agreements. Lauren F. mentioned the RAFT program. I'm not sure if any of you have worked with it before, but it's a arrearage assistance program. So tenants can apply for assistance through that program to get some back rent paid off. And we're also expecting a lot of negotiations on waiving some back rent, since the COVID-19 pandemic has caused people to lose a lot of income. It's unlikely that all landlords will get the full amounts paid off, and that is going to be something that's very prevalent in the negotiations. And then we also, like I said, need to consider negotiating for waiver of past rent and also potentially lower rent moving forward. Some of the rental assistance programs will be conditioned on whether the tenancy is sustainable. So if the landlord wants to receive some of that assistance, they may have to reduce their rent moving forward. But again, attorney for the day programs are available in most of the courts, and the tenant just has to ask. So please remind people that they can access legal assistance before they sign off on something. Then unfortunately, we are expecting more than usual. Some tenancies will not be able to be saved. They won't be able to be preserved. So unfortunately, some families and individuals will have to rely on shelter. The state of Massachusetts has a family shelter system, the Emergency Assistance Shelter Program, that's run by DHCD. And this is something that a lot of families, unfortunately, will have to rely upon if they cannot stay in their homes. So it is limited to families with kids under 21 or pregnant women, and the gross income has to be at or below 115% of the federal poverty guidelines. There are also other more detailed eligibility requirements, and something in terms of thinking about negotiating agreements is that the language in these agreements has to be such that it doesn't cause a family to be ineligible. So another reason we want people to consult attorneys for the day before they sign off, because you don't want to sign off an agreement that will somehow make a family ineligible for shelter. And the attorneys for the day will have some guidance on what shouldn't go in those agreements. Right now, instead of walking into the EA shelter program to apply, all of the applications are being done by phone. So if you are working with a family that needs to access shelter, you should direct them to this phone number that's listed here. And these slides can be shared afterwards as well. To make the process quicker and easier, we recommend that the applicant brings all of their identification documents, or has them ready. I guess in this case it would be scanned. Just to avoid delay, we do think that it's unlawful to require this up front, but again, for practical purposes, to avoid delay, we recommend people do come prepared with all of their documents. An important thing to remember if members or constituents are asking questions about this, the shelter system is statewide, so people can be placed anywhere, and they might see delays if, for instance, they're requesting to stay in Boston due to medical care or something. That could happen, but it might take a while for something to open up or for the program to accommodate that. And if you reject a placement, it can lead to ineligibility for a significant period of time. So people just have to be aware of, what the rules are before they agree to apply and before they reject anything. If you are working with families that are experiencing delays or denials when trying to access it, programs like GBLS can help with accessing shelter, as well as when people are getting terminated from shelter. There is the website here that shows how you can find out where your legal services is in your area. So we cover Greater Boston, but there are legal services programs all over the state. So most importantly, how Lauren discussed in the beginning, the CDC moratorium is also in play. That is extending past Massachusetts, which is great. It is much more limited, but again, we do recommend that everyone who is unable to pay their rent does fill out the declaration that covers the requirements Lauren went through before. And then the RAFT program is here on this website at metrohousingboston.org. That's where tenants can apply for some back rent assistance. And then as Danielle and Lauren are going to go through the MAID program, we have that on our GBLS website. And as you'll see, it is very user-friendly, and it's definitely something that tenants may request assistance from your programs to help you go through. So does anyone have any questions right now, or we can also jump into the MAID program? All right, I'll hand it over to Danielle and Lauren. Stop my share.
All right, thank you, Dina and Lauren, I appreciate it. And just to let everyone know, you don't have to be named Lauren or a form of Laura to be a part of the housing unit, nor does your name have to begin with the letter D. So I know this is a weird configuration that we have going on here, but just wanted to get that out in the air. Okay, so now I will be discussing the MAID portion, which is the online database that will allow tenants to submit answer and discovery forms. You can't submit it directly to the court, but it will allow you to print the forms out. You can sign the forms electronically. A lot of advocates are able to print the forms and mail them for tenants due to some access issues. So that's what we will be discussing now. I'm going to share my screen here. And I did put the link to MAID in the chat box, and it's also in the presentation that Dina and Lauren were just sharing. So this is the first page that you'll see when you pull up www.gbls.org/MAID. And it's got a host of information. It does come in different languages, which is helpful. There are different samples. So if you're unclear as to what forms you should have in front of you, it does give you an idea of what the form should be. And you can start the online form, but before we do that, I just wanna also scroll down that there's, in the event that you still have some questions after this training, there is a training with some corresponding slides at the bottom of the page, so you can scroll down and see information related to that. So when you're ready and you have either the tenant with you or them on the phone, you can start the online form. And this program is very user-friendly, and it comes with instructions and pictures so that you can follow along easily. So this is the first page that you get to. It asks you, you know, gives you a time limit. I promise you this will not take 90 minutes. And it gives you what you should have in front of you. And when it gives you a green prompt, you can usually click that, and it gives you a sample of what it is that the document should look like. So the summons and complaint will look like this, and your notice to quit will probably look like this. And that's the information that you should have in front of you when you're ready to start the program. So you hit next. And who is completing the interview? You can say the tenant or the helper. We'll just say the tenant is filling, or the helper is filling out the form. It goes through a series of informational questions. You can feel free to read through it, but for the sake of time, we'll say I agree. And then I also want to mention that in every page, there's a play button. So instead of, which I hope it'll play. I don't know if it will.
Language,
okay.
English, Espanol.
Okay, so you can, I don't know what that was, but anyway, so it has instructional videos before you start. So it gives you a lot of information well before you start, just in case you're a little hesitant of going forward. So there's a little video I'll show very briefly, maybe 10 seconds of it.
This video is an overview of the evictions process in Massachusetts. The most important thing to know about evictions in Massachusetts is a landlord must take you to court if he wants to move you out of your apartment.
All right, so you get the gist. It gives you a video. It's about 3 minutes long, and you can follow through and understand landlord-tenant law within 3 minutes and 50 seconds, apparently. So we'll go to the next slide. All right, so this is where you start to actively input information into the system. So it'll ask you certain questions regarding your upcoming court date. Do you have a court date coming up? And it'll give you different options to select from. You can always select the help button if you have questions. And I believe that takes you to a prompt where it'll tell you different information about where you are, but you can always go back to the question. And we'll say that, yes, we have a scheduled court date, and hit next. And then for the address, and I believe, let me just, for the address, you want to put in, you know, whatever the address of your tenant, where the tenant lives. So let's say that the tenant lives at 120 Tremont Street in Boston. And luckily, this form will generate the information for you, which is nice. And you can just put in whatever number. You don't have to put the number in, but it is helpful if the court needs to contact individuals. And then you can put in your email address. And you can say, this is also the address I am being evicted from. Yes, sometimes it is no, because a tenant may have moved out and the landlord may be seeking rental payments and not possession from the tenant. So that's why they have that question there. So you hit next. What is your name? You just go into what your name is, and we'll use Sarah Smith. An example, we'll hit next. If there are additional tenants, so usually if you have adult children that live with you or you have a roommate, you would say yes or no. So here we would just say, is there another tenant? So no, and we move on. So this part of the form is asking you to look at the summons and complaint, and it's really cool because they, in this little section here, they give you where you should be looking at on the summons and complaint. And again, if you're unsure if you're looking at the correct document, you can always just click the summons and complaint prompt and it'll show you, yes, okay, this is the document that I'm looking at. And every summons and complaint looks the same, so you don't have to worry about whether or not a different court is using a different document. So this question asks, does the line to the defendants contain something other than Sarah Smith? And the reason they're asking this question is sometimes the landlord may have your name incorrect or may list a party that doesn't live there, or just may have your name misspelled, which could be grounds to dismiss the case. So usually you just want to make sure that the information that is here is listed correctly. So here, no, there's no other names. And you hit next. And then this is a very cool prompt. Individuals can get reminders of their court date. So you can always put in a phone number if you want, or you can just skip this function if you're in a hurry, or you can put an email address if they want to get information via email. So your landlord's name, again, they'll tell you on the summons and complaint where you should be looking. And then they give you a zoomed in format of where the landlord's name would be. So our landlord today is Frank Jones, and you hit next. And then the next question is, what type of landlord do you have? This is important because you want to be sure that if your landlord is an LLC, they have to be represented by an attorney. If your landlord is a private individual, that's fine. Or if it's a housing authority or like the Boston Housing Authority, that's important to note as well. So here, I believe our landlord is, I don't know, what is our landlord? None of the above, I would say, just to make things easier. So we hit next. If your landlord is just a private landlord, meaning that he just rents the apartment to you, you can just hit none of the above or I don't know and hit next. Does Frank Jones have an attorney for this case? No, he does not. So we'll hit no. In some instances, if you want to hit, if the landlord is represented, it will ask you for the landlord's name. Excuse me, for the attorney's name. And again, here we'll tell you where you can find the attorney's name. It's usually at the bottom here, and it'll say signed by the attorney. But here in this instance, we don't have an attorney on the case, so we hit no. And we hit next. In what court is your case being heard? Again, here it's a zoomed in form, the zoomed in summons and complaint form of where you can find this information. So our case is in Boston, so it's the Eastern Housing Court. And what is the date of your first court hearing? So again, we can just put in, and this is important as well, dates are very important because it will determine when your, whether or not your answer is on time. And if it's not, you may have to file a request to file a late answer, but it also will let you know whether or not you are filing in the right court essentially, because some courts have specific dates that they have hearings on. So that can also be a prompt as well. But because of the pandemic, all of the cases are to be determined. But for today's purposes, we'll put that our hearing date is on the 26th. And usually the answer is due, as it says here, this is usually on a Monday. So for this, we'll say it is due on the 19th. And then we hit next. And it says, great news, we're filing on time. So this portion is probably going to be a little different as it says. It says your hearing may happen on a different day and time. And now the new protocol is that the hearings are now in different tiers. So there's a tier 1 and then there's a tier 2. The tier 1 case is meant to be a mediation or a status conference of sorts. And the tier 2 portion or hearing is meant to be a hearing or a trial if you need it. So usually what the court, or not usually, what the court now is doing is the first date that you receive, your answer will be due 3 days prior to that. So if the first date that we receive is November 9th, if November 6th isn't a weekend, then our answer will be due on November 6th. So I just want to make sure that's clear going forward, because this system hasn't been updated to reflect that. But it does give this message here that your hearing may be different due to COVID. So now we get into the reasons for the eviction, and then it tells you right up front what you need to be looking at. So you look at your notice to quit, and this is what the document should look like. Notices to quit can vary, but usually on the front page it will say 30-day notice or 14-day notice to quit. So that's important that you are looking at what type of notice you receive. There's either a 14-day, that's usually for non-payment cases, or there is a 30-day notice, which is for fault and no fault cases. So here you can pick the reasons as to why the landlord is evicting you. So for our case, it's a 14-day notice, which means the landlord is saying that we owe rent. In some cases, you can have a mixed bag of non-payment and fault. So it's important that you make sure that you're reading throughout the whole notice so that you understand exactly what the landlord is alleging, so that if you have any defenses, you can raise those, and we'll get into that later. So for today's purposes, the landlord is evicting us because we owe money. So you just click, my landlord says I owe rent, and you hit next. And then defenses for your case. And it gives you some information in cases like yours. You may win your case if you have at least one claim against your landlord. So for instance, for non-payment cases, you can raise a defense that says, I didn't have any hot water for 3 months. I told my landlord about it. I called inspectional services about it. The landlord didn't cure or didn't fix it. So that's why I withheld rent. So that would be a defense as to why you didn't pay your rent. So that's what they mean for when they mention defenses for your case. And then they ask you information about your family. They want to know who's living there. And this is an opportunity as well. If the English is not your first language, that's something that you want to point out as well, because a lot of times landlords may send notices to quit that are not in your first language, and that's not valid. So that's something that you want to raise here or be aware of. So you can just click, a lot of times with the cases that Dina and I work on, which are mostly reasonable accommodation cases, a lot of people have disabilities. If you have children, you want to click someone with me is under the age of 6. Or if you're an elder, someone that lives with me is over the age of 60, and then you can hit next, or whichever of these apply. You want to make sure that you're capturing everything that is going on with that particular tenant. And then your rental agreement, a lot of times people don't have their lease or don't know where it is when it's time to fill this portion out. So if you don't have it, you don't have to fill it out, but it is helpful to get an idea as to when your rental payment or when your rental period started. And then it will give you these select questions as to how much you pay for rent. So let's say this person pays $1,000 a month. It's monthly. They do have an option for weekly. There are some places where tenants pay weekly rents. And then my rental agreement is a lease or month to month. I don't have one. I don't know. So let's say this person has a lease. You hit next. And then this asks you what type of notice to quit. Again, whenever you see the green, you can click on it to be sure that you're looking at the right document. So it asks you the kind of notice to quit, 14-day, 30, 72 hours. 72 hours usually if there's threat of violence or a health and safety issue that would require immediate court intervention. So this is a non-payment case, so it's 14 days. Again, if it's a fault or no fault, it would be 30 days. The notice to quit has my name on it. The notice to quit includes everyone who signed the lease. And this is just a recap of everything that we just went through previously, so to make sure that you're inputting the correct information. But I do want to let people know that you can always go back. So if you're working with a tenant and they have to pick up their child, or they have to go back to their desk, or whatever the reason is they can't continue, you can always save it or share it with someone. So that's important to note as well. So we'll go next because all of this is correct. This question says, my lease requires a 30-day notice even for non-payment. That can be in some instances. And then if it's a public housing or a subsidy, there is required language that is mandated that be on a notice to quit. So if that's missing, that would be the box to click. And there's always a question mark. And it tells you answering this question probably requires the help of a lawyer. You can leave it blank if you are not sure. So we hit next. Non-payment defenses. Lauren, is this your part or am I still going? I'm still going? I think I'm still going. I just feel like I've been talking a lot, but I'll keep going. Okay, non-payment of rent defenses. Like I mentioned earlier, there may be instances where you didn't pay your rent because there were insect infestations or rat infestations, no hot water, that sort of thing. And you did everything in your power to alert the landlord and he still wouldn't fix it. Or there could be an instance where your landlord inadvertently raised your rent and didn't talk to you about it. Or you could have paid the amount, and this case is pointless or moot, and you offered to pay or you offered to cure. So these are options that you could select. So you could say, I was behind on my rent or I was not, whichever you think it is applicable to your particular situation. So we hit next. Information about, so they always ask about the property to make sure that where you're living, if there are other claims of defenses that you could raise, that those can be brought in the forms that are produced for the court. So a lot of people pay utilities. If your landlord tried to lock you out because you didn't pay the rent, you could click that. Or I paid a security deposit, that's always a big one. Or I prepaid last month's rent when I first moved in, that's also another possibility as well. And then you just go through the type of lease that you have. A lot of people don't know what type of lease they have. Some leases renew for another term, some are month to month. So you could say it ends and doesn't renew, or renews for another term. And we hit next. And then this asks you the timing of the notices. So it again, if it's green, you want to click that to make sure that you're looking at the right document. So you want to look at the notice to quit and not the summons and complaint. So the date I got the notice, we'll say we got it October 1st. We hit next. Well, that doesn't give you, I think that gives you 14 days. Okay. And then it says find the line on your summons and complaint that begins with because. And then again, if you're unsure if you're looking at the right document, click the green script. And what does your summons and complaint says is the reason? Does it match the notice to quit? This is important because a lot of times landlords may say they're evicting you for one thing in the notice to quit, but then say, oh, just kidding, I'm actually going to tack on these other issues in the summons complaint, which again isn't valid and could be grounds for dismissal. So all of these are correct. So we hit yes, the summons and complaint includes the names, it has my correct address, and it matches the notice to quit. So we hit next. And then there's a video here as to whether or not you were served properly. So this database or this system is really meant to make sure that you are covered, basically. So we don't want to cause you to miss out on a defense that you could have raised. So it, really takes you step by step as to whether or not these things were proper. So we're saying that we got the notice to quit on the 1st. and the date that you actually got the notice may have been the 5th or something to that effect. And then it asks you how you actually received it. So someone handed it to me, the summons complaint was mailed, or the summons complaint was left in my apartment. So clicking on, one of these, however the person received it, is important, because there are service of process requirements when you do file a summary process case. So if that wasn't done properly, again, that can be grounds for dismissal. So let's just say the summons complaint was left at my apartment, or someone received it. Okay, so paying the money owed. So this is a non-payment case. So it's a 14-day notice to quit. And it says here, you may have the right to stop an eviction if you paid all of the money that you owe to the landlord no later than October 19th. So here we can say I paid the court costs, or I paid all the rent, or I offered to pay. So we'll say that. So a lot of times you want to offer, a lot of times tenants do try to cure their rent, meaning they try to pay what is owed prior to coming to court. And sometimes landlords don't accept that. And the court doesn't appreciate that from landlords. So that's why we include that section here, because when we get to court, the landlord or the judge can say, well, this person tried to pay you on September 30th. Why didn't you accept it? And so the date I paid my landlord, or the date I paid my landlord was, let's say, the 8th. And we'll go to next. Okay, so waiver creation of a new tenancy. This is important because sometimes notices to quit can be very confusing and be very vague. So I paid rent after October 1st, or I signed a new lease, or none of the above. Does a notice to quit say rent will be accepted for use and occupancy? And here you can say, if you're not sure what the terms mean, if it's green, that means you can click it and try to get more information. So that's what this question is asking. Did the notice to quit include this statement, basically? So our notice to quit did include that. So we hit next. And yay, we have defenses. So your landlord might not have followed all the technical steps to legally evict you. Only a judge can decide that. So we hit continue, and we go on to our the defenses that we have. So I'm going to switch it over to Lauren to take over. Lauren H.
Thanks, Danielle. So Danielle, if it's okay if we can continue to share your screen and I'll just talk, I guess.
Yep.
Okay, so let's just assume that the person has bad conditions, which we can use as both a defense and a counterclaim. And counterclaims are things that the landlord may not have done correctly, which could actually be worth money. So if you scroll down, there's a list of problems that are options for tenants to choose from. So we could just say that there were mice, or no heat, or not enough hot water. And these are all things that, again, for particular cases like no fault or non-payment, can be used for money and a defense to possession. So we could just click next. And then in order to be able to claim these things, the court wants to make sure that you notify your landlord, and that can be done in writing or verbally. So we could check that I told the landlord in person. Also, we encourage tenants to call, if they're in Boston, to call ISD, which is the Inspectional Services Department. And that's really good proof of bad conditions as well. And so these are just other options that the court could use, or that the tenant could use, to show that the landlord was made aware of these problems. Okay, so we could go to the next one. This is sort of tricky, repair and deduct. In some cases, tenants, if landlords really are refusing to fix things, tenants may want to repair things and then pay for it and deduct it off the rent. So we could choose that. And then it gives other options as well. It's sort of a tricky statute, so we don't always encourage it, but it's definitely an option for some tenants. So we could say that, yeah, that's a perfect one. And then we could just go to the next slide. Okay, retaliation means that your landlord is evicting you for something that you had a right to do. It could be that maybe you made a complaint maybe the tenant made a complaint about bad conditions, and then within 6 months of that time, the landlord served on to them a notice to quit. So anything that's a protected activity that occurs, and then within 6 months, if the landlord is then terminating the tenancy, we would consider that retaliation. And so in this instance, Danielle checked off that the tenant withheld rent, that they reported bad conditions. And so all of these things are protected. And so if the landlord took steps to then terminate the tenancy, we would consider that retaliation. And it just goes through other protected activities such as domestic violence or a survivor of abuse. Those are all things that are protected under the law. And this is if the tenant feels as though the landlord is evicting them based on discrimination, and these are the categories of discrimination. So if the tenant said that they're being discriminated against based on race or religion, they're able to check that off as well. And it applies to members of the family too. So we can move to the next slide. Breach of quiet enjoyment happens when the landlord does something or allows something to happen that interferes with the tenant's enjoyment of the unit. So if there was a party and the tenant notified the landlord and the landlord didn't take steps to rectify it, that could be considered a breach of quiet enjoyment. Or if there was not enough heat in the winter or not enough hot water, these are all things, again, that are both defenses and counterclaims for tenants who are being evicted for no fault or non-payment of rent. Interference with utilities is another issue. So if the landlord did not handle the utilities correctly, so if the tenant was illegally billed for heat or hot water, there are options there. These are all things that the landlord should adhere to under the law. And then the security deposit. So oftentimes tenants will give first, last, and security deposit. The security deposit is a really precise statute. And so there are very strict regulations as to how the landlord needs to take care of the security deposit. And so it lists the violations. And a lot of times we encourage tenants that even if they're not sure if the landlord did or did not do things correctly, that if there's any inclination, we just check it off as a place marker. So we could say that, the landlord did not keep it in a separate bank account free from creditors, that the tenant was not given receipts. Any of these things could be used by the tenant to get 3 times the amount of the security deposit. So it's really important that, that tenants are aware of their right. And then the consumer protection law has to do with like illegal things that the landlord may be engaging in, such as charging late fees before rent was 30 days late, or charged court fees or constable fees unlawfully. Not as common. And then as Danielle said, a lot of times there's cases involving disability that Gina and Danielle are focused on. But if somebody in the household or the tenant are disabled and there's a direct connection between the disability and the reason for an eviction, tenants have a right to request a reasonable accommodation from their landlord. And this can be a defense. And so what's cool about MAID is that it will actually generate a reasonable accommodation letter to the landlord when it prints out the answer and discovery. So that's really important. And then this is the jury trial. We always encourage tenants to claim their right to a jury trial, because if it's not claimed later on, you can't go back and say, oh, I want my jury trial right. It's either you choose it or you lose it. And so the jury trial is really good in several instances, because if the case were to go to trial, it would be heard in front of a jury of one's peers. But it essentially is really good for buying time. It allows tenants to return at a later date. They can collect evidence. It's really a good thing. We always encourage tenants to claim their right to a jury trial. This box allows tenants to explain to the judge why they would need more time to move. And so a lot of times, if you're in front of a judge that's really compassionate, they'll consider the fact that they're disabled, that they're elderly, that they have nowhere to go. It's really your opportunity to share with the judge why you would need more time to move. And like Dina mentioned, it's really difficult to find a place. So you know, we always encourage tenants to seek more time than they think would be necessary. And it says almost done, which is great. And it gives you the option to change any things if you need to. And then it will generate. And so now, I guess we can go through this rather quickly, but the discovery portion of the answer and discovery just means that these are things that you need to fully prepare for your case if it were to go to trial. So it's questions that you want the landlord to answer, and it's documents that you want the landlord to send to you. And again, this was already mentioned. So the first portion, you can check off up to 30 types of questions that you would want the landlord to answer pertaining to your case. So you can customize it or keep the default selections. Either one is fine. I guess we could keep the default. And then it's really, the MAID tool is really cool because you can just sign it using your finger, and you can do it from your phone. You can sign on this computer screen, or else it allows you to print it and sign it once it's done printing, and then you can mail it in that way. So I guess however. Okay, so once you've completed your answer and discovery, it has to go both to the court and to the landlord. And so it gives a date as to when the forms would be due, but again, this may change based on COVID. So if we were to email this, right now with COVID, landlord attorneys have to accept service by email. That may not apply for pro se landlords, but we can choose email because I think that's probably the most effective, time-effective way of doing it. And then this option just says that if the tenant qualifies for legal assistance, it could be considered by Greater Boston Legal Services. Okay. Yeah, good choice. And then one portion that I just want to get to, I don't know if it's going to come up yet, is that with COVID-19, tenants are going to have, if they use this system and they choose not to print it out, they're going to have to e-file their responses. And if tenants can go to masslegalhelp.org, it'll show, and I think this was already discussed on the slides by Dina and Lauren, it will show how to actually create an account and to e-file. It's a little tricky, it's free, but the instructional video should work. Oh, thanks, Danielle. That's great. Yes, okay, so this is how you would upload your answers from MAID, your answer and discovery, to the court. So it has these instructional videos. It would just be a little bit too time consuming for us to go over all of this. Thanks. And so congratulations, you finished. And these are really the best, the answer and discovery are really the best things that tenants can do to protect themselves in an eviction case. And it just reviews. So, and it explains how to file and serve. Thanks, Danielle.
Thanks, Danielle and Lauren. So that's how you do the MAID answer and discovery. And I think now we have time for open question and answers to discuss any issues that you all might have on your minds in terms of what you're expecting to see, or any other questions for us. We're happy to answer what we can.
Feel free to either unmute yourselves or submit your question in the chat. Or not.
Well, if people don't have questions, we can circulate the slides, so then you'll have the websites that we talked about specifically, and most importantly for the CDC declaration, which is something the tenants who are facing eviction and cannot pay their rent need to sign. And we are really prioritizing getting those in, because that can stop the landlord from moving forward in either filing a case against you or just moving forward in a current case. As we mentioned before, some courts and landlords are interpreting it differently than we interpret it, and expecting that the case can go forward, but that it would hold up the ultimate eviction result until after December 31st of this year. So we're emphasizing people to get those in. That website is in the slides. It's a online tool that was made at the Suffolk Law School, and it is very simple for a tenant to walk through. It has narration for someone who it can't read it, and also is in 2 different languages. And then the MAID system, we also have the website for. So hopefully trying to make all these tools accessible to you and your organizations, and the numbers for contacting us to see if we might be able to take cases is also in the slides. And yeah, thank you for joining us to see how we can all work together to help tenants and members and participants. And I'm seeing a chat. So thank you for coming, Juliet. Yeah, and hopefully we'll have some more trainings in case people missed it, and we want to just get the word out, because we know all hands will be needed to help people stay in their homes.
Well, thank you so much, Dina, Danielle, Lauren, and Lauren, for just a very informative session and training about all these resources and tools that are available. And with that, thank you all. And the recording of this will be made available online on the Zakim Fund's YouTube page.
Awesome. Where can we find the slides?
We will be sharing them via email with those who registered.
Okay.
So you receive it in your inbox.
Thank you.
No problem. All right. Well, have a great day.
Thanks for
Thank you.
hosting us, Eric.
Bye.
Thank you. Bye.